All right, we're on the record on State versus Lloyd. Mr. Lloyd's present with his attorney. State attorney's office is present. Mr. Lloyd's dressed in a long sleeve button-down shirt, civilian pants. He is wearing shackles, but his feet are underneath the table and can't be seen by the jury. That's my understanding. It's been explained to you that I have gotten sicker and I don't have the energy to read these jury instructions. State, you have any objections to Judge Munyon reading them?
No, Your Honor.
Defense? All right, she'll explain it to the jury. I will be here during closings.
I do have one teeny request, and I'm not certain who to direct that to. We were going to ask if we could have one person be designated as the person to object during the state's closing if it necessitated. The circumstance should arise, and I understand the court's preference is typically, since it's Mr. Lemon doing the closing, that he would be objecting. I'm just asking, and I get not wanting more than one person, if we could designate Sandy well so we can finish his mental preparation, and she'll be the only person objecting on behalf of the defendant should we need to during the state's closing.
The person who does the closing has to object. It's an administrative rule here.
And the court wouldn't grant us any deviation from that?
No, ma'am.
And I am just here as a voice and to read. As soon as I finish reading the jury instructions, before the state starts their closing, I'm going to exit. All right. So any questions you have, just direct to Judge Marquez. I will explain to the jury that even though we look similar, we are not actually the same person. And I'm going to take my mask off while I read the instructions so that the jury can clearly hear me.
Your Honor, this is a small point, but I would likely be inclined to wait until you exit before I begin my, is that okay?
That's fine.
Thank you, Your Honor.
And we can bring the jury in when you're ready. No, I don't.
This is the agreed upon version, which
Okay.
I believe is that one.
Okay, good. Let's hope so. Looks like it's the same. Looks like it's the same thing. And if you need me to come back in and read the other part when they finish closing, let me know. Good morning, ladies and gentlemen. My name is Lisa Munyon. I'm the Chief Judge here in the Ninth Circuit. Judge Marquez is still here. Obviously, we are not the same person. I am here simply to read the jury instructions. As you probably deduced yesterday, she's not feeling well. And it was easier for me to be the voice to read the jury instructions to you. Have they been given a copy? All right, and you have your copy of the jury instructions. Feel free to follow along with me. We're going to start on, obviously, on page 1.
Sorry. Would Your Honor make the immediate inquiry?
Judge Marquez, do you wish to make the immediate inquiries?
Good morning. Have any of you had any contact with anyone who's tried to talk to you? Have any of you had any contact with anyone who's tried to talk to you about this case? I don't see any hands. Has anyone seen anything on television, read anything in the newspaper, the internet, anywhere, or heard anything about this case since you were last in this courtroom? I don't see any hands. All right, thank you.
Now we will begin. Members of the jury, you have heard all of the evidence and the argument of counsel, it is now your duty to make a decision as to the appropriate sentence that should be imposed upon the defendant for the crime of first-degree murder. And obviously, I'm going to read you part of the instructions now. The attorneys will give their closing arguments, and then the balance of the instructions will be read to you. You obviously have not heard penalty phase arguments at this time. There are two possible punishments. One, life imprisonment without the possibility of parole, or two, death. In making your decision, you must first unanimously determine whether the aggravating factors alleged by the state have been proven beyond a reasonable doubt. An aggravating factor is a circumstance that increases the gravity of a crime or the harm to a victim. No facts other than proven aggravating factors may be considered in support of a death sentence. The aggravating factors alleged by the state are: 1, Markeith Loyd was previously convicted of a felony and on felony probation at the time the first-degree murder was committed. 2, Markeith Loyd was previously convicted of a capital felony or a felony involving the use or threat of violence to another person. First-degree murder with a firearm and killing of an unborn child by injury to the mother are capital felonies. The crimes of battery on a law enforcement officer, resisting a law enforcement officer with violence, attempted first-degree murder with a firearm, as to Joseph Carter, attempted felony murder with a firearm, as to Stephanie Dixon Daniels, attempted felony murder with a firearm, as to Dominique Daniels, aggravated assault with a firearm, and carjacking are all felonies involving the use or threat of violence to another person. The first-degree murder was Number 3, the first-degree murder was committed for the purpose of avoiding or preventing a lawful arrest. 4, the first-degree murder was committed to disrupt or hinder the lawful exercise of any governmental function or the enforcement of laws. 5, Deborah Clayton was a law enforcement officer engaged in the performance of her official duties. Pursuant to Florida law, the aggravating factors of avoiding or preventing a lawful arrest, disrupt or hinder the lawful exercise of a governmental function or the enforcement of laws, and that Deborah Clayton was a law enforcement officer engaged in the lawful performance of her official duties are considered to merge because they are considered to be a single aspect of the offense. If you unanimously determine that the aggravating factors of avoiding or preventing a lawful arrest, disrupt or hinder the lawful exercise of a governmental function or the enforcement of laws, and that Deborah Clayton was a law enforcement officer engaged in the lawful performance of her official duties, have all been proven beyond a reasonable doubt, your findings should indicate that those 3 aggravating factors exist, but you must consider them as only one aggravating factor. You have heard evidence about the impact of this murder on the family, friends, and community of Deborah Clayton. This evidence was presented to show the victim's uniqueness as an individual and the resultant loss by Deborah Clayton's death. However, you may not consider this evidence as an aggravating factor. As explained before the presentation of evidence, the state has the burden to prove an aggravating factor beyond a reasonable doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to disregard an aggravating factor if you have an abiding conviction that it exists. On the other hand, if after carefully considering, comparing, and weighing all the evidence, you do not have an abiding conviction that the aggravating factor exists, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the aggravating factor has not been proved beyond every reasonable doubt, and you must not consider it in providing a verdict. A reasonable doubt as to the existence of an aggravating factor may arise from the evidence, a conflict in the evidence, or the lack of evidence. If you have a reasonable doubt as to the existence of an aggravating factor, you must find that it does not exist. However, if you have no reasonable doubt, you should find the aggravating factor does exist. A finding that an aggravating factor exists must be unanimous. That is, all of you must agree that each presented aggravating factor exists. You will be provided a form to make this finding as to each alleged aggravating factor, and you should indicate whether or not you find each aggravating factor has been proven beyond a reasonable doubt. If you do not unanimously find that at least one aggravating factor was proven by the state, then the defendant is not eligible for the death penalty, and your verdict must be for a sentence of life imprisonment without the possibility of parole. At such point, your deliberations are complete. If, however, you unanimously find that one or more aggravating factors have been proven beyond a reasonable doubt, then the defendant is eligible for the death penalty, and you must make additional findings to determine whether the appropriate sentence to be imposed is life imprisonment without the possibility of parole or death. If you do unanimously find the existence of at least one aggravating factor, and that the aggravating factors are sufficient to impose a sentence of death, the next step in the process is for you to determine whether any mitigating circumstances exist. A mitigating circumstance is anything that supports a sentence of life imprisonment without the possibility of parole, and can be anything which might indicate that the death penalty is not appropriate. It is not limited to the facts surrounding the crime. A mitigating circumstance may include any aspects of the defendant's character, background, or life, or any circumstance of the offense that may reasonably indicate that the death penalty is not an appropriate sentence in this case. It is the defendant's burden to prove that one or more mitigating circumstances exist. Mitigating circumstances do not need to be proven beyond a reasonable doubt. Instead, the defendant need only establish a mitigating circumstance by the greater weight of the evidence, which means evidence that is more likely than not tends to establish the existence of a mitigating circumstance. If you determine by the greater weight of the evidence that a mitigating circumstance exists, you must consider it established and give that evidence such weight as you determine it should receive in reaching your verdict about the appropriate sentence to be imposed. Any juror persuaded as to the existence of a mitigating circumstance must consider it in this case. Among the mitigating circumstances you may consider are: 1, the first-degree murder was committed while Markeith Loyd was under the influence of extreme mental or emotional disturbance. 2, the capacity of Markeith Loyd to appreciate the criminality of his conduct or to conform his conduct to the requirements of law was substantially impaired. 3, Markeith Loyd's age at the time of the crime. 4, the existence of any other factors in Markeith Loyd's character, background, or life, or the circumstances of the offense that would mitigate against the imposition of the death penalty, including but not limited to: A, Markeith Loyd suffers from delusional disorder, which is a diagnosis on the psychotic spectrum. B, Markeith Loyd was a victim of kidnapping and beating when he was 17 years old, along with his friend Tyrion Wesley. C, Markeith Loyd saw the dead body of his cousin Wesley Harp after he was shot and killed in the street when Markeith was 16 years old. D. Markeith Loyd watched Roots, Rosewood, and Mississippi Burning at an extremely early age, and being exposed to the violence inflicted upon Black people depicted in the movie had a lasting impact on Markeith, particularly how he perceived race relations. E. Markeith Loyd witnessed the KKK marching in his neighborhood after his mother relocated the family to the Pine Hills neighborhood in search of a better life for her family. F. Markeith Loyd was standing on a street corner when he was 20 years old with his friend Antoine Glover when a car pulled up and someone from inside the car opened fire. Markeith fell to the ground believing he was shot. Antoine was hit. G. Markeith Loyd suffers from post-traumatic stress disorder as a result of having suffered multiple complex traumas. H. Markeith Loyd had a disadvantaged childhood. I. Markeith Loyd suffers from brain dysfunction as a result of multiple traumatic brain injuries. J. Markeith Loyd has a learning disorder. K. Markeith Loyd did not learn to read until he was in the 3rd grade. This fact went undetected by the school system and his mother until then. L. Markeith Loyd was committed to the Laurel Oaks treatment facility by his mother. He did not receive the care or treatment he needed and convinced his mother to check him out of the facility when he was 16 years old. M. Markeith Loyd offered to turn himself into law enforcement after the death of Sade Dixon if law enforcement would correct the inaccuracies regarding the circumstances of her death being portrayed in the media. N. Markeith Loyd's father abandoned his family, then died when Markeith was still very young. O. Growing up without a father exacerbated Markeith Loyd's symptoms of Markeith's mental illnesses and reduced his coping skills mechanisms. P. Markeith Loyd's mother was not around when Markeith was a child. Q. Markeith Loyd's mother beat him until he cried with extension cords, belts, switches, and her hands. R. Markeith Loyd's grandfather taught him the game of buying and selling illegal drugs when Markeith was a child. S. Markeith Loyd's mother would lock up the limited food and resources in her bedroom to keep the supplies from the children. T. Markeith Loyd stole food to care for himself and his younger siblings, starting when he was 8 or 9 years old. U. Markeith Loyd was sentenced to a lengthy prison sentence for the possession of drugs that did not belong to him. V. Markeith Loyd's lengthy prison sentence occurred as the result of the over-prosecution of crack rock cocaine. W. Markeith Loyd was stabbed in federal prison. X. Markeith Loyd witnessed a man within his unit beaten to death by other inmates while Markeith was in federal prison. Y. Markeith Loyd was robbed at gunpoint twice while delivering Texas chicken. Z. Markeith Loyd's co-worker was shot and killed delivering Texas chicken. AA. Markeith Loyd peacefully surrendered to law enforcement on January 17, 2017. BB. Markeith Loyd was badly beaten by law enforcement during the course of his arrest on January 17, 2017, causing numerous abrasions and cuts, and most significantly, an inferior orbital blowout fracture with a corresponding ruptured globe that required surgery, resulting in the loss of Markeith Loyd's left eye, and now is permanently blind in that eye. CC. Law enforcement delayed in providing medical care to Markeith Loyd after his arrest. DD. Markeith Loyd wanted to turn himself in after the death of Lieutenant Deborah Clayton in a way that would result in the reward money being offered for his arrest going to Sade Dixon's family. Markeith Loyd was affected by racism personally, but has also been traumatized by law enforcement's use of force against Black men and children generally, notably the killings of Tamir Rice, Philandro Castile, and Alton Sterling. FF, based on Markeith Loyd's delusional belief that law enforcement was out to kill him, he was in an enhanced fight or flight mentality at the time he shot Lieutenant Deborah Clayton. GG, Markeith Loyd is a generous man who takes care of people in need. HH, Markeith Loyd ensured that Jesse McCree watched out and financially provided for Tamara Croker, the mother of his son, Markeith Loyd Jr. II, Markeith Loyd has the love and support of his friends and family. JJ, Markeith Loyd is the most important person in Kiana Lloyd's life. KK, Markeith Loyd provided love and affection to his granddaughter, Kalia. LL, the existence of any other fact in the defendant's background not mentioned above that would mitigate against imposition of the death penalty. Your decision regarding the appropriate sentence should be based upon proven aggravating factors and established mitigating circumstances that have been presented to you during these proceedings. You will now engage in the weighing process. You must weigh all of the following. A, whether the aggravating factors found to exist are sufficient to justify the death penalty. B, whether the aggravating factors outweigh any mitigating circumstances found to exist. And C, based on all of the considerations pursuant to these instructions, whether the defendant should be sentenced to life imprisonment without the possibility of parole or death. The next step in the process is for each of you to determine whether the aggravating factors that you have unanimously found to exist outweigh the mitigating circumstances that you have individually found to exist. The process of weighing aggravating factors and mitigating circumstances is not a mechanical or mathematical process. In other words, you should not merely total the number of aggravating factors and compare that number to the total number of mitigating circumstances. The law contemplates that different factors or circumstances may be given different weight or values by different jurors. Therefore, in your decision-making process, each individual juror must decide what weight is to be given to a particular factor or circumstance. Regardless of the results of each juror's individual weighing process, even if you find that the sufficient aggravating factors outweigh the mitigating factors, the law neither compels nor requires you to determine that the defendant should be sentenced to death. Once each juror has weighed the proven factors, he or she must determine the appropriate punishment for the defendant. The jury's decision regarding the appropriate sentence must be unanimous if death is to be imposed. To repeat what I have said, if your verdict is that the defendant should be sentenced to death, you must have unanimously found that at least one aggravating factor was proven beyond a reasonable doubt, and you must find that the aggravating factors are sufficient to impose death and outweigh the mitigating circumstances. You will be provided a form to reflect your findings and decision regarding the appropriate sentence. If your vote on the appropriate sentence is less than unanimous, the defendant will be sentenced to life in prison without the possibility of parole. The fact that the jury can make its decision on a single ballot should not influence you to act hastily or without due regard to the gravity of these proceedings. Before you vote, you should carefully consider and weigh the evidence, realizing that a human life is at stake, and bring your best judgment to bear in reaching your verdict. When considering aggravating factors and mitigating circumstances, it is up to you to decide which evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in making your decision as to what sentence should be imposed. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: 1, did the witness seem to have an opportunity to see and know the things about which the witness testified? 2, did the witness seem to have an accurate memory? 3, was the witness honest and straightforward in answering the attorney's questions? 4, did the witness have some interest in how the case should be decided? 5, did the witness's testimony agree with the other testimony and other evidence in the case? 6, had the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? 7, did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? 8, has the witness been convicted of a felony or of a misdemeanor involving dishonesty or false statement? The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give an opinion. However, an expert's opinion is only reliable when given on a subject about which you believe that person to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. The defendant in this case has become a witness in the guilt phase. You should apply the same rules to consideration of his testimony that you apply to the testimony of the other witnesses. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. The defendant exercised a fundamental right by choosing not to be a witness in the penalty phase. You must not be influenced in any way by his decision. No juror should ever be concerned that the defendant did or did not take the witness stand to give testimony in the case. These are some general rules that apply to your discussions. You must follow these rules in order to make a lawful decision. You must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. Your decision must be based only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of exhibits and evidence and these instructions. Your decision must not be based upon the fact that you feel sorry for anyone or are angry at anyone. Remember, the lawyers are not on trial. Your feelings about them should not influence your decision. Your decision should not be influenced by feelings of prejudice, racial or ethnic bias, or sympathy. Your decisions must be based on the evidence and on the law contained in these instructions. And ladies and gentlemen, the balance of these instructions will be read to you after the closing arguments from the state and the defense. At this time, the attorneys will make their final arguments. Please remember that what the lawyers say is not evidence or your instruction on the law. However, do listen closely to their instructions or to their arguments. They're intended to aid you in understanding the case. Judge Marquez has been sitting here the entire time and is going to come back to the microphone.
Thank you very much. Any objections or additions from the state to the instructions?
No, Your Honor.
Defense? Before you all start, the verdict forms are up here.
May I
One
approach?
copy for each side. There you go.
Thank you.
Mr. Williams, you may proceed.
Thank you, Your Honor. May it please the court, counsel. An author once said that responsibility is the thing that people dread most of all. And you all have come face to face with the truth of that statement over the past months. You all were selected and asked to give your time and attention, time away from your jobs and loved ones, to take on an awesome responsibility, to listen to facts and evidence of a horrific act and provide your voice as to what the appropriate punishment should be for the murder of a law enforcement officer. And you have taken that responsibility very seriously. You've not only faced it, but you've embraced it, your role as jurors in this case. But your responsibility is the only responsibility present in this courtroom over the last few months. Because having heard the evidence in this case of Markeith Loyd's guilt, the evidence of this man's life and his crimes, you know that responsibility plays no role in his story. This man's life, the evidence has shown, is one of blame. It is one of avoidance. It is one devoid of responsibility in all aspects. And ladies and gentlemen, that makes you and this moment what Mr. Lloyd dreads most of all. This is his moment of responsibility. Now, you've been given instructions, and having found Mr. Lloyd guilty of first-degree murder, the only thing remaining is to determine whether or not Mr. Lloyd spends the rest of his life in prison without the possibility of parole, or if he is eligible for a sentence of death by this court. The instructions that you were given and that we're going to discuss at length over the next few minutes provide a detailed process that allows you to go step by step using evidence, reason, and logic to reach the ultimate opportunity to make your reasoned moral judgment. So for the next few minutes, I'd like to talk about that process and the evidence that you've heard and how that process leads you, we believe, to conclude that Mr. Lloyd and his crimes warrant a sentence of death. Now, you all sat and listened to the multiple steps that you all have to take in order to reach a lawful verdict in this case. And I'm going to take a moment here to submit to you that the process itself is important and that you not deviate from that process. Now, we'll come back to this again, but you have a duty to deliberate in this case. And there's been discussion during jury selection and at multiple times during the trial about what it means to deliberate. And while it is true, as you've been told several times, that your decision as to whether or not a sentence of death is appropriate is an individualized decision, that is nothing new to you. That is something you have already done. Because what your instructions in the law tell you is that each of you reach an individualized decision, and only if you're unanimous that death is the appropriate punishment can it be imposed. The only difference between what you're being asked to do now and what you did in the first phase of this trial is that we tell you what happens if you're not unanimous. We didn't tell you that before, and now you know.
Overruled.
So it's going to be emphasized to you, and I will emphasize to you, that you're making an individual decision. But you did that in the guilt phase because none of you would have agreed to something as a whole that you didn't personally feel and agree to based on the evidence in the law. So that's the first thing that I want to emphasize as we go through this process. Now, I told you that you had a duty to deliberate, and that's not me. That comes from multiple instructions within this case that you've been given. On the screen, there's an instruction talks about aggravating factors, and it says, if after carefully considering and comparing and weighing all the evidence, and that's on page 2 of your instructions, after carefully considering, comparing, and weighing all the evidence. There are multiple places in your instructions. This one happens to be on page 3, where you're told to consider, where you're told to discuss, where you're told to deliberate. And this may seem like it's not important.
Overruled. Overruled.
And this may seem like a small point, but it's going to become important as this very important decision is made and how you reach it. And most importantly, on page 6 of your instructions, there's the quotation that's on the screen in front of you. And it very clearly says that before you vote, you should carefully consider and weigh the evidence and bring your best judgment to bear. So we would ask you to do that very thing. To, after the arguments are presented to you, to go back and each of you go through the process, look at the actual evidence, and weigh the aggravating factors. Consider the mitigating circumstances. Go one by one. Now, you're probably saying to yourself, Mr. Williams, why are you wasting our precious time standing here talking about something that we already know how to do? And that's a fair question. And the reason I'm spending that time is because it's been suggested to you at a few times that you have the absolute right to go back and vote and end this discussion once and for all. And that is true. We can't make you deliberate. But I would suggest to you that does not get us to a just verdict. I would suggest to you that, as the instructions point out, you have an obligation to give meaningful consideration to everything. And not only that, but that you try your best to reach a unanimous verdict. And I say that knowing...
Misstatement of the law.
Overruled.
I say that knowing that you all may unanimously decide that Mr. Lloyd deserves life in prison without parole.
Objection. Misstatement of the law.
Overruled. Mr. Lloyd, we do not need to hear from you. Go ahead, Mr. Williams.
This is an important decision, and all I'm suggesting is that you all collaboratively work together, understanding that you will make an individualized decision, to reach a decision that is commensurate with the task in front of you. So now we talked about the decision and how it's made and how the law colors that. Let's talk a little bit about the actual evidence and the first step in your process. And as the instructions told you, the first step in your process is to determine whether or not the state of Florida has proven at least one aggravating factor beyond and to the exclusion of every reasonable doubt. And in your instructions are the 5 aggravating factors that you are able to decide have been proven beyond a reasonable doubt based upon the evidence. Now, an aggravating factor, as we have discussed, is any fact that increases the gravity of a crime or the harm to the victim. And the 5 aggravating factors that are alleged in your instructions are on the screen now. And as we discussed, these are common sense things. These are facts or circumstances that take this murder, in the state's view, above and beyond any other murder that's been committed, which is what we would expect the ultimate punishment under the law to be imposed. It should be something above and beyond. It should be something extra. And in this case, that is what has been presented. Each of these aggravating factors were carefully considered and deliberated upon by people who make our laws, and they represent the principles that strike at the very heart of our system of governing. So what are the aggravating factors the state has proven beyond a reasonable doubt? The first one is that Markeith Loyd was previously convicted of a felony and on felony probation at the time the first-degree murder was committed. And you're going to hear me say this on several occasions as we go through this morning, but I don't believe there's any real argument about the fact that this aggravating factor has been proven. You heard the testimony of federal witness and federal probation officer DeCarlo Shepard, who told you that Mr. Lloyd was on a term of 5 years of probation that began in July of 2014 when he was released from federal prison, and that period of probation did not end until July of 2019. This crime, of course, occurred on January 9th of 2017, and Mr. Lloyd, according to his testimony and the evidence in the case, was on probation. The other fact that's significant about that is that you know that Mr. Lloyd barely made it halfway through his probation before he committed 3 murders. Now, I will talk to you more about the significance, the weight of these aggravators at the end. Right now, we're just going to go through the actual evidence that proves them beyond a reasonable doubt, because that is the first step that you're asked to take in the instructions. And I would submit to you that it will take very little effort, if any, to find that that aggravator is proven beyond a reasonable doubt, which takes us to the second aggravator, which is that Markeith Loyd was previously convicted of another capital felony or a felony involving the use or threat of violence to another person. So there are multiple capital felonies and multiple violent felonies in the history of Markeith Loyd. Sequentially, the first thing that you heard about was that Mr. Lloyd was convicted of battery on a law enforcement officer and resisting an officer with violence. In this document, the judgment and sentence from that 1998 case is in evidence. And you all heard the testimony from Todd Herb, who told you that when he conducted a traffic stop on Mr. Lloyd, asked him for his driver's license, Mr. Lloyd refused. And that when Mr. Herb attempted to take him into custody, Mr. Lloyd wheeled, turned, and struck him in the face with his left hand. And then, of course, you remember the testimony that ensued with the constant struggle and strikes that Officer Herb went through in the minutes that followed. Those are the first 2 prior violent felonies that you heard evidence of. And the photographs, like all of the evidence that will appear on the screen, are in evidence, and you can review them if you like. The next set of felonies, again going sequentially, prior violent felonies in time, occurred when Sade Dixon and her unborn child were murdered. Fast forwarding to December of 2016. And here again, you have the judgment and sentence is in evidence, and you can review it and take it back to you to the jury room. There's no doubt that we've proven that he's been convicted of these crimes. I want to talk about them separately, however, because the murder of Sade Dixon and the killing of her unborn child are both capital felonies. meaning that they are eligible or punishable by death if a jury like you were to find. And that's a distinction in the aggravating factor between not only felony, but also capital crimes. And those two were capital felonies, which you are aware he's been convicted of, and you heard evidence and testimony about that. But I don't want to overlook, however, the fact that those were not the only felonies that were committed that night. It is significant that there were 3 additional attempted murders that Markeith Loyd committed that night. And we'll talk about the weight that we're asking to give them. But he was also convicted from that night of attempting to murder Ronald Stewart, and then the attempted felony murder of Stephanie Dixon Daniels and Dominique Daniels as they stood in the doorway trying to render aid to their siblings and children and child. You know that he's been convicted of that not only because of the judgment and sentence that it's in evidence, but also because Stephanie Dixon Daniels testified here in this penalty phase as to what her role was that night and how that played out as Mr. Lloyd went to trial. So those 2 incidents bring the total number of prior violent or capital felonies in Mr. Lloyd's history to 7. 7 before the sun ever rose on the morning of January 9th of 2017. Now, the law says that you can consider the violent felonies from January 9th as prior violent felonies. And the reason that is because they occurred prior to this sentencing proceeding. Now, I would submit to you that the ones from December are more weighty because they occurred prior to Lieutenant Clayton being murdered. But for purposes of the law, these are prior violent felony aggravators. And you know, and in fact, you concluded that on January 9th, Mr. Lloyd, aside from his murder of Deborah Clayton, tried to kill Captain Joseph Carter, carjacked Antoine Thomas, and committed an aggravated assault upon Mr. Thomas. So, as Mr. Buxman pointed out in his opening statement, that is 10. 10 prior violent and capital felonies that Mr. Lloyd has been convicted of. There is no doubt, let alone a reasonable one, that this aggravator has been proven. So we'll move on to the 3rd aggravating factor the state has alleged, and we believe proven beyond a reasonable doubt. And that is that the first-degree murder was committed for the purpose of avoiding or preventing a lawful arrest. Again, I don't believe there will be any real dispute about this aggravator. Markeith Loyd had a warrant for his arrest for first-degree murder, the murder of Sade Dixon, on the morning of January 9th when he murdered Lieutenant Clayton. The warrant, as we discussed in the guilt phase, is in evidence, and I need to make an important point here. You all can and should consider the evidence from the guilt phase in this trial. We didn't go back and put it all in either side and recall witnesses because it's our expectation that you will consider that. So this is one of those facts that was presented in the prior phase that you can consider in considering the sentence in this case. So the warrant is in evidence. Detective Savelli testified to it. Takeshia Bryant testified to it. And of course, you heard Lieutenant Clayton's radio traffic where she talks about going to make contact with a homicide suspect. Of course, Mr. Lloyd himself told you that he was hiding out in the woods and that he sought out a bulletproof vest. And the reason he was doing all of those things was because he had a warrant for his arrest. Ms. Bryant, Monica Pridgeon, Julia Johnson, all of the witnesses heard lawful commands from Deborah Clayton to Markeith Loyd in the minutes before she was murdered. Not even minutes, the moments before she was murdered. Because she was doing what? Attempting to take Markeith Loyd into custody, attempting to arrest him for the murder of Sade Dixon. You also heard in this phase several witnesses talk about Mr. Lloyd's desire not to go back to prison. One of those witnesses was the pastor, Jesse McCree, who specifically said, quote, he did not want to go back to prison. Now, he was talking about how Mr. Lloyd was trying to do right, and I think there were other witnesses who talked about how Mr. Lloyd was trying to do right. But the clear statement that all of them made was that this man did not want to go back to where he had come from just years earlier. Even Barry Jacobs, his brother, when he was asked, if you recall, Mr. Jacobs was called to say that Markeith called him and wanted to turn himself in. Remember, he had to acknowledge that in that call, Mr. Lloyd said, excuse my language, I don't want to go back to that shit. And when I clarified with Mr. Jacobs, he made it clear that that meant he did not want to go back to prison. Even in the context of surrendering, or his statement he would surrender, we'll talk about that, he didn't want to go back. It was in his mind. And that, of course, is important because the reason he murdered Lieutenant Clayton was because he was not going back. He was going to avoid the arrest in this case, and if he had to take Lieutenant Clayton's life to do it, he would. And that is exactly what he did. And of course, you have the defendant's own words on Facebook about what it is and what he is able to enjoy when he's out of custody and what it would mean to have to give that up to go back in custody. By your verdict, you have already rejected the fact that, or the idea that Lieutenant Clayton was killed in self-defense. And you now know that Mr. Lloyd's use of violence when resisting arrest did not start on January 9th of 2017. There is overwhelming evidence of this aggravating factor, and we will ask that you find it when you go back and deliberate. The fourth aggravating factor is the first-degree murder was committed to disrupt or hinder the lawful exercise of any governmental function or enforcement of the laws. And if it sounds like there's a lot of overlap between this aggravator and the prior one, it's because there is. They look at different aspects of the same set of facts, so I am not going to spend a great deal of time talking about it. And the final aggravating factor is that Deborah Clayton was a law enforcement officer engaged in the performance of her official duty. And again, you all know that from all of the evidence presented up to and including the portions of the video, including portions where it was obvious and Mr. Lloyd testified that he saw her in full police uniform on January 9th. And the duty she was trying to perform was to bring Mr. Lloyd into custody for the murder. So the first step of your process is to find that we have proven at least one aggravating factor beyond a reasonable doubt, and I believe that we've just shown that we have proven 5, and that there will not be a significant amount of disagreement about that. The next thing that it's a little confusing in your instructions, but your verdict form is going to say is that you need to make a decision on the sufficiency of the evidence for a possible sentence of death. And what that means is, do you decide that there is enough evidence to consider a possible sentence of death? That is step 2. Without ever considering the mitigation, you look at the aggravating factors, the quality of them, and make that determination. And we will ask that you do that. And why is that step present? Because there are circumstances where we believe, I think arguably, a jury could find that it was not sufficient. Because the instructions tell you that if even one aggravating factor is present, you can go forward in the process, right? If the only aggravating factor in this case was that Markeith Loyd was on probation, would that be sufficient to warrant a sentence of death? Perhaps not. But we would submit to you that in the face of 5, what we will discuss, weighty aggravating factors, that decision, that evidence is sufficient. We'll ask you to go on to step 3. And step 3 is the consideration of the mitigating circumstances. Now, in your instructions, all of the mitigating circumstances alleged start on page 3, and they go on for about 2.5 pages, I believe. And I want to be very clear that the mitigating circumstances that are alleged are just like the state's allegations. They have to be proved. The language is what they believe they can prove or have proved to you in that statement. Because as you can imagine, we certainly don't agree with the wording of some of the things that they believe have been proven that are in your instructions. You all have given a lot of attention, so I am not going to go through every single point and every single mitigating circumstance that's alleged. I'm going to hit the ones that were discussed most often in the process. But I would hearken you back to, again, what Mr. Buxman suggested in his opening statement. When it comes to mitigating circumstances, there are 2 things to determine. Number 1, was it proven? And then number 2, what does it mean? Your instructions tell you that if you find that it was not proven, then you don't have to give it any weight whatsoever and consider it. But then, even assuming a fact is proven, does it have any significance? And I'll give you an example before we start talking about the big ones. On page 3, number 3 says Markeith Loyd's age at the time of the crime. Markeith Loyd, I think it's indisputed, is 46 now, which would have made him 41, I believe, at the time of the murder. How is his age mitigating in any way? He wasn't 19 years old. He's not 65 years old. With all due respect to the younger members of the jury, the prime of his life. There's no issues we would submit with his mental thought process. You all heard him testify. So was it proven that Mr. Lloyd was 46 years old or 41 at the time? Yes. What does that mean as a mitigating circumstance? And we would submit nothing. And that we would submit that it does nothing to mitigate this crime. So 3 things in the context of was it proven. Number 1, it's their burden to prove the mitigating circumstances. Not ours. They have to prove a mitigator for you to be able to consider it. Number 2, the burden of proof is lower. It is greater weight of the evidence, or 51%. And the third thing that's significant is that you do not unanimously have to find a mitigating circumstance. If even one of you finds that it's been proven, then you can all collectively consider it. That's the difference between the aggravators and the mitigating circumstances. So let's talk about the specific mitigating circumstances that have been put before you, or some of the specific ones. And the first one, it's on page 3, is number 1. The first-degree murder was committed while Markeith Loyd was under the influence of extreme mental or emotional disturbance. Now, the evidence of this mitigating circumstance came from various different defense experts. Dr. Jethro Toomer, Dr. James Campbell, Marvin Dunn, Dr. Mayer, Dr. Colino. They each testified for several hours, and I'm not, again, going to go through everything that they said, because I know that you were paying attention. But there are some specific things that I want to talk about that came up, and they are our belief as to why, when it comes to this mitigating circumstance, and the idea that Marquis Lloyd has a mental illness has not proven whatsoever, even by the lower standard in evidence. So the first thing I'd like to talk about is the bias of the witnesses. So let's go way back to the guilt phase of the trial when you heard testimony from Dr. Jethro Toomer. And what did Dr. Toomer tell you? Dr. Toomer told you that he has a moral objection to the death penalty, and that he does virtually all of his death penalty work if not all, on behalf of defense counsel. Now, he wasn't the only defense expert who said that, but he was the first to say it. Then there's Dr. Jeffrey Colino. He makes almost his entire living off of testifying on behalf of defendants in capital cases. And if you recall, I wrote it down, $52,000 Dr. Colino was paid by the defense for his opinion in just this case. And over the last 4 years, $1.5 million he's made working on behalf of capital defendants. Now, I want to be clear that we have no problem with people making money. Good for him. He's worked hard, went to school. But when there's evidence that a witness is substantially reliant on a specific set of people and outcomes, you need to consider that. Whether or not his testimony is truly objective. Whether it can be, with $1.5 million on the line, can it be objective? Or does his even subconscious bias start to creep in, knowing that in order to keep that money coming, there have to be specific findings and outcomes achieved? On the concept of bias, Dr. Colino also exposed another significant problem in his testimony. And it was a small thing that seemed like a small thing that came at the end, but Mr. Buxman asked Dr. Colino about whether, when he wrote the prescription, he asked anyone or the radiologist not to review it. And he told you that he specifically wrote in there not to review it. And that's even more significant to you now because you've heard the testimony of Dr. Jeffrey Nagin. Dr. Nagin is one of those radiologists who normally reviews those. And Dr. Colino admitted to you on the stand that he tells in his prescription in this case, and approximately half of the cases he does now, don't look at that. That's only for me to look at. Don't make an independent judgment on that. Now, why would he do that? Other than the obvious. And in fact, to his credit, he acknowledged on the stand that it's become practice in capital cases. Common practice. Half of the cases, the neurologist or anyone writing a prescription for that type of scan says, nope, please don't view it, Dr. Nagin or someone similarly situated. There's Dr. Mayer, who acknowledged giving a lecture at a seminar called Life Over Death. He tried to minimize it, saying it was a long time ago. But you also heard Dr. Mayer's regular tendency to miscommunicate what he's saying, and that goes to his credibility and his bias. And finally, I want to say that I am not suggesting to you that these individuals lied. What I am suggesting, and I believe there is evidence to support, is that there are aspects of what they do, why they do it, and how they do it that make it clear that they are not objective in their work, and that their opinions have to be carefully scrutinized. The second reason that the defense has not met their burden on this mitigating factor, and I would submit to you any of the mental health mitigating factors that are listed out in your instructions, is because of a lack of qualifications and the lack of diligence on behalf of the experts that they asked to give them to you. So there's an instruction on page 8 of your instructions that talks about evaluating expert witnesses. And what it says is that an expert's opinion is only reliable when given on a subject about which you believe that person to be an expert. And that makes sense, right? If your refrigerator breaks, you're not going to call a plumber to come and fix it. So you wouldn't give them any statements they make about your refrigerator any weight. And it's no different here, folks. And yet, that's what you heard from the defense experts in this case. It was revealed on cross-examination by Dr. Toomer that his PhD is actually in social and group processes, not in forensic psychology, not in clinical psychology. And then he sat on the stand and told you that he was board certified and left it at that. But on cross-examination, he was forced to acknowledged that his certification is actually organizational and business consulting. And he's asking you to accept his psychological opinion about Mr. Lloyd. Then there's Dr. Dunn. Unlicensed, never practiced clinical work, never practiced forensic work. He reads about stuff to keep up and keep current on his field, or what he says is his field. But what you heard is that he's never actually done the work that he's asking you to accept his opinion in. And the last time he was licensed, I had to think about this, I believe Richard Nixon was president of the United States. And many of you were not born. And yet he came in, gave you his opinion. He's entitled to do that. But you are entitled to consider it and reject it if he's not qualified to give it. And how many of these experts told you that they relied upon the work of other experts? Leaving aside the whole let's get our story straight conversation that they had together, how many of them came in and told you that they relied upon Dr. Sesta's report, only for it to be revealed that they disagreed with the conclusions that Dr. Sesta reached, and that they reached different conclusions? Now again, Dr. Mayer tried to paper over that, even though he first said that the DSM-5 was recognizable and authoritative. When it came to having to actually explain the different diagnoses, oh, well, it's just a coding manual for what we use for insurance purposes. But that's not what he said on direct examination. Again, another, I say second, but it's really a series of reasons why the expert opinion that you heard on this topic is simply not credible. And the final reason is reliance on faulty, incomplete, or unreliable information. The testimony that an expert gives you, as you now know, because you're essentially experts in psychology, is based largely on what they're told and what information they receive and review during this process. So I want to use Dr. James Campbell as a specific example of the faulty information that is relied upon, this garbage in, garbage out process. Now, I would argue to you that Dr. James Campbell was the best defense expert and that his credentials were the best. What he said made the most sense, and in fact, he was the only expert from the defense who went through the DSM-5 and explained the specific criteria of the diagnosis he was giving, and then gave you the facts upon which he relied in reaching that diagnosis. And it's our view that that makes him credible. The problem that Dr. Campbell had, and again, to his credit, he acknowledged it, is he was relying on Markeith Loyd. Multiple criteria, and he told you, a lot of the information that he gets is subjective and cannot be corroborated. Multiple of the PSD criteria, he says, came strictly from Mr. Lloyd and were unverified. And that's another important aspect of the mental health diagnosis in this case, by all of the defense experts, is they all rely on the reports of who? The defendant and his family members. Reports given to them after this man was charged with first-degree murder. 3 counts of it, actually, in 2 separate cases. There are no records substantiating what these doctors told you. There's no indication that Mr. Lloyd ever sought treatment for a mental illness. There are no prior diagnoses. There's 0. So I have a hard time blaming Dr. Campbell for reaching the conclusion he did based upon the evidence he had, but is that evidence reliable? Is it in fact true that Markeith Loyd was avoiding the things that he tells you were distressing him? When he continued to deliver chicken night after night carrying a firearm? When he says he was experiencing traumatic stress from the chicken robberies? And yet it's clear that it wasn't so traumatic that it stopped him from working in the same job, even though you heard evidence that other jobs were available. Is it true that these symptoms were so severe that they interfered with his daily living, his social, occupational, or other functioning? No. And Dr. Campbell's testimony on this point is very important. I asked him, well, what is your basis for that? Well, Mr. Lloyd told me that he was having a difficult time going out at night and delivering chicken. Really? Is that what you all heard about Mr. Lloyd's level of functioning in 2016? Of course it's not. You know what the evidence has been, that he was a highly functioning, highly intelligent, very busy and active individual. Is there evidence that he had clinically significant distress or impairment? No, there is not. I would even point out something else that might have gone overlooked. Dr. Campbell talked about Mr. Lloyd's startle response. Remember that? Specifically, he talked about how when he was in the jail, Mr. Lloyd would flinch and click whenever the doors closed or clinked. Go back and look at the video to his granddaughter. On multiple occasions, the doors are slamming and closing, and Mr. Lloyd never flinches at all. Just continues the conversation, going on normal. Because Mr. Lloyd does not have PTSD or post-traumatic stress disorder. He's not delusional. These are aspects of blame, of the need to place blame elsewhere. And that, ladies and gentlemen, is just the defense testimony. That's their burden, is to prove this. And that's the evidence they gave you. And I would submit to you that they didn't come close with the evidence they gave you. But of course, that's not the only evidence that you heard in this case, because you heard from the defense experts, Dr. Gamache, Dr. Werner, and Dr. Nagin. Dr. Gamache and Dr. Werner both told you that Mr. Lloyd had no diagnosable mental illness. End of story. And I want to specifically focus on Dr. Werner's testimony, because Dr. Werner doesn't get paid for her work, at least not extra. She works at a clinic for low-income people. She sees patients day in, day out, 7 days a week, including patients with a background and racial makeup just like Mr. Lloyd. She had by far the least bias in evidence of any witness that's testified before you. And what did she say?
Objection, voucher.
Sustain. Rephrase.
Her background and experience and testimony establishes that she had no recognizable bias. And she told you that Mr. Lloyd is not mentally ill. If you find Dr. Werner's testimony, just hers, credible, I would submit to you that you cannot find that these aggravators exist. Because there's a clear conflict in the evidence, which you all know when evaluating the evidence, a conflict is one of those things that you can consider and should consider. They pointed out that there was no evidence in the records. And I also want to bring up something that Dr. Gamache said, only because it was seconded by a defense witness. When asked about the delusions, Dr. Gamache said, Mr. Lloyd is not delusional. He accepts aspects of certain belief systems that are common in our country, the ones that suit him, that he likes, and he then uses that to establish a belief system that to him makes sense and allows him to rationalize his behavior. That was Dr. Gamache's testimony. You heard that from a defense witness, Mr. McCree. Jesse McCree got on the stand, and remember he tried to describe to you Mr. Lloyd's religious beliefs. And he said, Mr. Lloyd, he kind of takes from different religions the aspects of those religions that he likes, and the ones that he likes he accepts, and the ones he doesn't he rejects. He's not really one part of it. The defense own witnesses. And Mr. McCree, to his credit, he wasn't trying to agree with Dr. Gamache. He was just describing what he observed. And what he observed is consistent with what Dr. Gamache told you. Mr. Lloyd is not delusional. He adopts aspects of other people's belief systems and uses them to rationalize his own behavior. So, was it proven that Mr. Lloyd has an extreme, because it doesn't just have to be a mental or emotional disturbance. The law says an extreme mental or emotional disturbance. No. And if you find that it was, I would ask you to ask this question. How did it impact Mr. Lloyd's life? Based upon the evidence that you have. And we would argue to you that the mitigating circumstances have the most weight if they somehow explain or contribute why the crime was committed. How did that, what you heard, do any of that in this case? The reality is that there is no evidence or testimony that any hypervigilance or anything else contributed to Markeith Loyd pulling a firearm and chasing Lieutenant Clayton and shooting her in the back as she ran away, and then standing over her and ending her life. So the next mitigating circumstance I want to talk about is the allegation that Mr. Lloyd's capacity to appreciate the criminality of his conduct or conform it to requirements of law was substantially impaired. And my recollection is that the only testimony of this came from Dr. Colino. And it came at the end of his testimony, and he was asked this specific question with this specific language. And he clarified that in his view, Mr. Lloyd understood or appreciated the criminality of his conduct. And here again, you all have already made this determination. You, by rejecting his insanity defense, you have determined that he knew the difference between right and wrong or that it was unlawful.
Judge, misstatement, Judge.
Overruled.
So what you're left with is Dr. Colino and his testimony that Mr. Lloyd couldn't conform his conduct. Well, Dr. Colino didn't explain why he believes that. Didn't say a word about it. What evidence is there that Mr. Lloyd was unable to conform his conduct to the requirements of law? In fact, as Dr. Mayer had to acknowledge, the records from the Orange County Jail, where Mr. Lloyd was staying after he murdered Lieutenant Clayton, indicate that he was able to. In fact, they changed his confinement level based upon his willingness to do so, to do that very thing, to follow the laws and rules and regulations. There's no evidence that he couldn't conform his conduct to requirements of law. And that leaves aside that Dr. Nagin completely blew up Dr. Colino's testimony by saying that, yes, he, in his expert opinion, evaluated the scans and that the scarring was normal, that all of the scans were normal. So the final aggravating factor is really several, which are described and laid out in your instructions. And they start at number 4 on page 3 of your instructions, and that's the ones that go all the way through. And like I told you, I'm not going to go through each and every one of them with you, but there are a couple of them that I think warrant some discussion. Starting with the defendant's childhood. It's been argued to you, or it's been said that Mr. Lloyd had to steal food as a child, and that he grew up impoverished, his mother beat him, and that essentially he had a very rough and bad childhood. I would concede that multiple members, at least of Mr. Lloyd's family, said that he was struck with an electrical cord, extension cord, and beaten. And there were times that members of his family went to bed hungry. And that is a true tragedy for any child in this country to go to bed hungry. The problem with the testimony from Mr. Lloyd's siblings and family members is that it's completely inconsistent with anybody who was not a member of the family, or even who was an adopted member of the family. If Mr. Lloyd's childhood was really so bad, why were they constantly bringing in other people to live with them? And all of those people describing a loving childhood where they had food to eat and clothes to wear, and they felt loved. I specifically remember Marco Moten testifying, and you can recall his testimony as you remember it, but he was the one who was homeless as a child. And he specifically said that living in the Lloyd household with Patricia Lloyd, who treated him like a son, was the best thing that happened. He didn't describe any of those things that you heard about from the Lloyd siblings. There's a clear conflict in what Mr. Lloyd's upbringing was. But as I said, I concede that Mr. Lloyd did not have the same upbringing as somebody who lives in Winter Park, a white child from College Park. I think that is absolutely proven. It's proven. What does it mean? What is the evidence that that is tied? It doesn't have to be tied for you to consider it, but that is tied to this crime in any way.
Objection.
And
Misstatement of the law.
Overruled. This is argument. Go ahead.
And, I'm sorry, Judge, I didn't mean to cut you off. And in fact, the evidence is that the opposite is true. Because you all know that all of the other children who were raised in that household, who had the same experiences or similar experiences and circumstances, turned out to be functioning, well-adapted, employed, hardworking adults. Tanya Lloyd, employed, working, very proud of the work that she does. Barry Jacobs driving a truck. Not perfect people, but certainly not murderers. That evidence is the strongest evidence of what, if anything, this evidence, this mitigation means in this case. They took responsibility for their lives, and it changed the outcome of it. The second one, the defendant was beaten up at age 17. Here again, we agree that there is evidence that Mr. Lloyd suffered a beating when he was 17 years old. All of the people who testified, including non-family members, said that he was beaten, and you heard that there was a police report that was filed in regards to Tyrone Wesley's report of that incident. I don't believe that there's evidence that you can rely upon as to how it happened, and the strongest evidence is that he and Mr. Wesley robbed the wrong person. Does that justify him getting beaten? Absolutely not. But again, what does this mean in his life? Because Mr. Wesley and another witness, I can't recall who, but I know there were two, said that Mr. Lloyd and Mr. Wesley were joking about this within a couple of weeks. One witness said, "Oh, Mr. Lloyd," another witness said, "I had no observations of any changes in the behavior after this." Did this incident have any impact on Mr. Lloyd long term? And the evidence is mixed at best. Does it prove it? I would submit to you no. But even if it does, what does it mean in the context of his life? Is it truly mitigating? The defendant is a generous person and loving father. And we would submit to you that the most powerful testimony you heard came from Kiana Lloyd, Mr. Lloyd's daughter. And the videos that you saw of him interacting with his granddaughter. And I believe there's evidence, and I think it makes sense that Mr. Lloyd loves both of those young girls. I would further acknowledge that they love him. And the problem with this mitigating factor, however, even being found, is that the evidence is that he does not love them more than he loves himself.
Objection.
Overruled. This is argument.
Any parent knows that the first thing they think of when making any decision in their lives is how it will affect their children. Something as simple as staying late for work and missing a practice or a game, let alone taking a job or moving to a different house. People know that. The love for a child means that they dominate the center of your universe. And I don't need to explain any further. And ladies and gentlemen, that is not the evidence about the way Mr. Lloyd conducted his life. You all know that his daughter was of a young age when he not only began but continued to sell drugs. He had to know the risk he was putting himself at, and that could easily result in his separation from her. And if he didn't know that back in 1998 and 1999, he certainly knew it in 2016. He knew that breaking the law because he was on probation would result in his separation not only from his daughter, but from his granddaughter. And why did he do that? Doesn't mean he doesn't love them, but it does mean that he loved himself more than them. He took that risk. Even before he murdered Sade Dixon, he took the risk of carrying a firearm, violating his probation, smoking marijuana. Why? Is that risk worth being separated from the person you say means more to you than anything in the world? And a parent knows that that's just not the case. And it brings me no joy to say that. And we feel for Kiana Lloyd, and it's not her fault. But you all are confronted with evidence in this case that regardless of how Mr. Lloyd says he feels about his children and family, he's made decisions that he knew would separate him from them. The defendant was wrongfully convicted. That's not the way they worded it on there, but I went back and recall Mr. Defense Counsel saying in his opening statement that Mr. Lloyd was wrongfully convicted for conspiring to traffic in cocaine. And I'm going to spend a moment talking about this, and I'm sure you were wondering why we spend so much time calling witnesses on this topic. And the reason is because it is the centerpiece, in our view, of their presentation. And that is that Mr. Lloyd was discriminated against wrongfully because of his race, because of the color of his skin. He was wrongfully convicted, and that colored the rest of his life. Is the evidence in this case that Mr. Lloyd was wrongfully convicted of conspiring to distribute cocaine? No. And it's not close. You heard from Agent De Palma, who told you about the physical evidence that was found as a result of the search warrant. You heard Mr. Lloyd's own words from the Assistant United States Attorney, Kevin Whitmore, who testified to Mr. Lloyd's entering a plea. I understand defense counsel is going to stand up here and say they relied upon a CI and the CI lied about his name. Mr. Lloyd accepted responsibility then. Now, he was wrongfully convicted. Even if you leave aside all of the evidence about what actually happened in the apartment and what was found, every single person who knew Markeith Loyd came in and told you that it was common knowledge that he was dealing drugs at the time. So even if you come to the conclusion that those were not his drugs, was his punishment morally wrong? When there's an acknowledgement that he was, to use his words to his sister, poisoning his community? That's the evidence in front of you. And it's being argued as a mitigating circumstance to you. And that brings us to the concept that Mr. Lloyd surrendered and the law enforcement use of force in this case. Now, I saved these two facts, these two mitigating circumstances for last, and you can probably imagine why. You can probably gather, or did gather, that we objected to this evidence ever being admitted and putting in front of you. And the reason is simple. It has no bearing. Our view is that it has no bearing. Our view is that it has no bearing on the murder of Deborah Clayton. So we called, well, let's start with the fact that we knew we would have to call Officer Jonathan Cute, and did, and Stacy Sammons, to talk about why what happened that night, how it occurred, and how it was viewed. And while their testimony establishes the very rational reasons why the actions that were taken, it's something that we wish never would have happened, if for no other reason than we're standing here talking about it now. So let's talk first about the surrender. We would submit to you that there is not evidence that Markeith Loyd wanted to surrender at any point. If Markeith Loyd wanted to surrender for the murder of Sade Dixon, he could have during any one of those 30-something days between when he was actually apprehended. And the most obvious fact you have of that is that Markeith Loyd watched Deborah Clayton walk out of the Walmart pushing a shopping cart on the way to her vehicle. He knew he had a warrant, he knew he was wanted, and here is an African-American female officer, 2 hands on a shopping cart, no threat to him. He could have walked up, tapped her on the shoulder, and said, I have a warrant for arrest. Here I am. Put me in handcuffs and let's go in. And folks, that would have been the end of it. But Markeith Loyd didn't do that. And we've already discussed all the reasons why he didn't do that. Because he wasn't going to go back to prison. You know now, because again, defense witness Derek Harris told you that the U.S. Marshals were doing anything they could to bring him in peacefully. They were communicating with members of his family and friends, like Mr. Harris, telling him, look, he tells us when and where, and we don't even care who he has with him, if he will just turn himself in peacefully. And you know, Mr. Harris told Markeith Loyd that. And did he surrender? No, he did not. Even on the night of the apprehension, the evidence suggests that Mr. Loyd was not going to go quietly. You heard testimony, not just from Officer Cute, but from other officers, that there was radio traffic that Mr. Loyd attempted to run out the back when he first became aware that law enforcement was present. And then he attempted to run out a side door when he became aware that law enforcement was present. He never told law enforcement he was unarmed and he wore a bulletproof vest. The only evidence that Mr. Loyd was going to surrender peacefully comes from statements that he made that are unsupported and uncorroborated. Now I want to talk about the use of force. And as I alluded to before, what does this, which is horrible, we acknowledge it is ugly, and we acknowledge that, have to do with this? Or this? Or this? Or this? How is an event and actions taken by people completely unrelated to Deborah Clayton that happened after he murdered her mitigate this murder?
Objection, Judge. Statement of the law.
If you have an answer to that, ladies and gentlemen, then that will be your finding. But following his apprehension happened 8 days later. How did those actions, whatever you believe, whether they were lawful or not, you heard testimony that charges were not filed. But let's just to say that you disagree with that. Let's just say that you believe Officer Cute or Lieutenant Cute and the other officers involved should have been charged and should be in prison right now. That's fair, if that's what you believe. But what does that belief have to do with this? How does that change the person that murdered Lieutenant Clayton? And we would submit to you, ladies and gentlemen, that this information, this evidence has been put forward to inflame you. to make you upset and mad at law enforcement. And I can certainly see why that would be the outcome. Without the details, why you would feel that way. Now, Lieutenant Cute, told you why he did what he did, and there are rational reasons for him doing so. But even if you disagree, is that mitigating to this murder? And that's the decision that you'll have to make. And moreover, it's a decision that, again, is a function of Mr. Lloyd's conduct and behavior beginning on December 13th and all of the things that law enforcement knew as they went into the apprehension that night, including his refusal to surrender to law enforcement. Markeith Loyd is not a victim, and we implore you to reject the evidence that suggests, or that they would like you to believe, establishes that he is. Now, that is my discussion of the mitigating circumstances. And in the process, and as it goes, you will have to determine what mitigating circumstances were proven. And then once you determine if any of those mitigating circumstances were proven, you will go to the next step in this process, which is weighing the evidence, the aggravators and mitigators. But before you do that, I want to make a brief statement about the victim impact evidence that you heard. Now, the law says you are not and cannot consider that as aggravating factors, or as an aggravating factor or a reason to sentence Mr. Lloyd to death. You can only consider it for the loss to the community and that it suffered as a result of Lieutenant Clayton's death and the uniqueness of her, who she was. She was a person from Carver Shores who grew up and made something of herself. She was a mother. She was a friend. She was a wife of 1 year. And she made it her mission to bridge the gap between law enforcement and the community. And that's all you can consider it for. But we'd ask that you remember that testimony. Which brings us to the weighing process. Was it proven, and what does it mean? So we're going to go in reverse order, mainly because I've already talked to you about the weight of most of the mitigating circumstances, or the weight we believe it should be given. And specifically, some of the mitigating circumstances that were suggested to you. Markeith Loyd became a drug dealer, we would submit to you, because it was easier to make money as a drug dealer than to do honest, hard work. And yet, he blames his upbringing and his childhood. Each of these mitigating factors we would submit to you as evidence of his refusal to accept responsibility. He went to prison because he sold drugs, and to use his own words, because he poisoned the community. But their view is that it's because system is racist, and so is law enforcement. Markeith Loyd murdered Sade Dixon and her unborn child, and tried to kill several other members of her family because she wouldn't let him control her. Remember, that was what Dr. Dunn said his view was, that he wanted to control women, and Sade Dixon was not to be controlled. He blames the media, mental health, and Ronald Stewart, the engineer brother. He murdered Deborah Clayton because she was going to send him back to prison. And here again, it's Deborah Clayton pulled a gun on him, and he has PTSD. Blame, blame, blame. What you've heard from Mr. Lloyd is that nothing is ever his fault. So that, we submit to you, means that you should give the mitigating circumstances, those that are proven, very little weight, if any. Which leads us to discuss the aggravating factors. And we would ask you, again, to ask yourselves, why is this aggravating factor significant? What about it is important? So let's start with the felony probation aggravator. Our laws say that it's aggravating if a person is on felony probation when they commit a murder. And why is that? Because probation is monitoring. It's a form of punishment that's an alternative to taking someone's freedom. It's our system's way of saying, you have broken the law, but here's your opportunity to live at large and show us you can do so. Show us you can do the right thing. And the law says that when a person is given that opportunity, a second chance, and they use it to commit murder, there's a recognition that the punishment should be more severe. Markeith Loyd knowingly violated the terms of his probation well before he murdered Sade Dixon, and then he was on probation when he murdered Sade Dixon and Lieutenant Clayton. And we suggest that you give this aggravating factor some weight, though not as great as the factors that we will discuss here in a moment. So the next three aggravating factors are all on the screen. The avoiding arrest aggravator, hindering law enforcement or lawful exercise, and the fact that she was an officer. And the law tells you, as you probably noticed or heard, that because all of these aggravating factors deal with different aspects of the same facts, that you have to consider them as one when it comes to the weighing process. So following the law, that's what you need to do. Even though, to be clear, that on your verdict form, you have to check each individually, and you'll be asked to do so. So what is it about these aggravating factors that makes them aggravating in the first place? And we'll start with the first one, that crimes that disrupt or hinder our governmental functions strike at the heart of what makes our democracy special. And that is a simple principle, that we adhere to the law. We follow the law whether we like it or we don't. And that's what separates us from every other country, typically, in this world. When you think about it, your service or anyone's service as a juror is predicated on that same thing. Because jurors are given an oath that they will fairly and truly try the case of the state of Florida against whomever. And without following that oath, you know now, having sat through it for 2 months, that you cannot ensure that justice is done. And that example shows us just how important adherence to the law is before our democracy, frankly and simply, tumbles. Markeith Loyd's attack on Deborah Clayton was not just an attack on an innocent woman. It was yet another statement by Markeith Loyd that the laws do not apply to him, that he does not need to adhere to them. And it's a statement that, left unchecked, will result in the unraveling of our democracy. So then you talk about the avoid arrest aggravator, and as I said, they're very similar. They both deal with Mr. Lloyd's failure or refusal to adhere to the law. So we talk now about the fact that Deborah Clayton was a police officer. And why does the mere fact, I say mere, fact that she was a law enforcement officer hold a special place, an aggravating factor or aggravating place in our law? And the answer is because they are the ones tasked with the, frankly, dirty business of making sure that other people do what they're supposed to do. They protect us in our community. When someone is in danger, when someone feels scared, what do? They call for a law enforcement officer to respond to their home, or their job, or the roadside. Police officers help people change tires. They provide CPR when people are unresponsive. They watch over us from the moment that we are children in school all the way to making sure that the cars properly get to the graveside when we die. Whether we like it or not, they've become a major part of our lives here in this country. And the truth is, we take them for granted. We take for granted that officers will go towards the danger when other people won't. And I talked about this in the closing of the guild phase, and I won't bemoan it anymore. Other than that, Lieutenant Clayton literally died trying to protect others. And ladies and gentlemen, that is highly aggravating under our laws. And we would ask that you find that to be the case and that you give this collection of 3 aggravating factors great weight. And that brings us to the defendant's prior violent felonies, which is the last of the 5th aggravators that I'll discuss. And on the screen are 2 reasons why we believe that this is the weightiest and most significant aggravator that you've been presented with in evidence over the course of the last few weeks. Why is it important or significant that an individual has, on a prior occasion, committed a capital offense or a violent felony against another individual? The first reason is that we know that it's not an isolated incident. People make mistakes. Sometimes they act harshly. Sometimes they even just demonstrate poor judgment, willing, knowing, but poor judgment in the moment. And they can do some horrific things based upon that. And when an individual has prior violent felonies, and in this case, 10 of them, it is indicative that this is not just bad judgment. It is indicative that violence is in Mr. Lloyd's nature. It is a part of the very person that he is. And what's particularly noteworthy about Mr. Lloyd's prior violent felonies is how varied they are. Right? So if Mr. Lloyd only committed violent crimes against law enforcement officers, there might be some validity to the idea that he has delusions about law enforcement officers. If he only committed crimes against a certain race of individuals, we might think there's some validity to the idea that that his views on race color that. But that is not the evidence before you. The evidence before you is that he battered a white law enforcement officer who tried to take him into custody. Even if you accept his view that he thought that Sade Dixon and Ronald Stewart were going to try to kill him on December 13th, then why did he shoot at and try to kill the family members? All African American. It's been suggested that Mr. Lloyd is a loving father, that he killed the woman carrying what he believed to be his daughter, his own child, resulting in the child's death. The evidence is that Ronald Stewart was on his back next to the front door of his home and that Mr. Lloyd stood over him and shot him, which is not surprising given the evidence that you know and have seen with your own eyes as to how he killed Lieutenant Clayton less than a month later. His violence is not about race or police or women. It is part of exactly who he is. The other reason that Mr. Lloyd's prior capital and violent felonies are significant is because they demonstrate the need for equity and fairness in sentencing. Because the defense has, on several occasions, in fact, I believe every single witness that they called, they brought up the fact that Mr. Lloyd was serving 2 life sentences in prison. And they believe, I suppose, that that is mitigating.
Sustained. Rephrase.
What I would submit to you is that the fact that Markeith Loyd is already serving 2 life sentences,
Overruled. I haven't heard what he's going to say. Go ahead.
that the fact that Markeith Loyd is already serving 2 life sentences indicates that a life sentence in this case
Overruled. Go ahead.
Is-
Mr. Lloyd, not
is no punishment at all.
Objection.
overruled.
That is the evidence and the reality before you.
Mr. Lloyd, settle down or
The
you're going
reality-
to be removed.
The reality here, and in the sentencing, and I'm just going to keep going, let him talk. The reality here is that Mr. Lloyd, and it's in evidence,
Please remove Mr. Lloyd.
Objection, Judge.
Mr. Lloyd, you've been warned repeatedly. If I hear from you again, you're being removed. Do you understand me? Mr. Williams, you may continue. No, sir. Remove Mr. Lloyd, please. Am I going to hear another word out of you? All right, thank you. Mr. Williams, you may continue. If he talks again, he's out. Go ahead.
yes, Your Honor. On the screen in front of you are the judgment and sentence for the Dixon murder. And they tell you what you already know, which is that Mr. Lloyd sentences not just for the murders of Sade Dixon and her unborn child.
Objection, Judge.
Overruled. Continue.
He was given life for the attempted murder of Ronald Stewart, the attempted murder of Stephanie Dixon Daniels, and the attempted murder of Dominique Daniels. Is another sentence of life appropriate in this case?
Objection, improper argument.
Overruled.
The reality is it would be another piece of paper in Mr. Lloyd's file.
Objection, improper argument.
Sustained. Rephrase.
I have a motion, Judge.
Not right now. Go ahead.
The question is the murder of Lieutenant Clayton the same, or is it so much more? Is it aggravated? We would submit to you that the 5 aggravating factors in this case, which must collectively be viewed as 3, are extremely weighty, and that they vastly outweigh the mitigating circumstances, which frankly have not been proven to you, but even if they are proven, deserve very little weight. And once you make that determination, The last aspect of your decision will be what the appropriate punishment is for Mr. Lloyd's crimes. And that's that moral judgment piece that we have discussed at certain times and talked about during jury selection. And it is undoubted, I am confident that counsel will argue to you that mercy is warranted in this case, and that you can give it even if it's not warranted, and that is accurate. The law never requires you to vote to impose a sentence of death, and no one will ever suggest it. But what you all know is that there are 10 pages of instructions and a detailed process that we just walked through, step by step, that guide your decision. And if after listening to the evidence and determining that there are multiple weighty aggravating factors that are present, and determining that they outweigh the mitigating circumstances that you've heard, then a decision for mercy is unwarranted, is what we would argue to you. And that it is an emotional decision where reason and logic
Overruled. Go ahead.
should be used. It is understandable to be emotional about what you've seen and heard from both sides in this case. But we would argue to you that the law is most fair and most just when logic and reason are applied. Now, your task is an understandably very difficult one. And the reality is that you all will remember what happens in the next few hours or days for the rest of your lives, and you'll never forget this experience. And that's a good thing, because the decision you're being asked to make is very important. And you have a lot of responsibility. But what I want to remind you is that the ultimate responsibility sits right there. This man is responsible for his choices. This man is responsible for where he sits and what the ultimate outcome of this proceeding yields. Life is unfair and it is unjust, but we make choices. We all make choices that determine the path that we take in our lives. And it is Mr. Lloyd's choices, it is Markeith Loyd's choices that brought all of us here today. And we ask that for the first time, you hold him responsible for his choices and vote to recommend a sentence of death in this case. Thank you.
Thank you, Mr. Williams. Ladies and gentlemen, we're going to take a break now before the defense does their closing. So why don't you return to the jury room, about 15, 20 minutes. Mr. Lenneman, you have a motion you want to make?
Yes, I have two. I have an objection to Mr. Williams' last statement, which was referencing.
You mean the very last statement of his argument?
Yes. Which referenced the recommendation statement. I believe that was intentional on Mr. Williams' part. After we discussed this in length throughout the proceedings leading up to this, and I would move for a mistrial just on that.
All right. Mr. Williams?
It was not intentional, it was not violent of any court order, and it's not even error under the law.
He did say recommend. We did discuss it, but why do you think it was intentional?
Well, first of all, you said he couldn't do it, Judge. And so if he heard you couldn't do it, and then he gets up there and the last thing he says is that word recommendation. I think it's pretty obvious that's an intentional act.
Right. It's not reversible error, so shouldn't have done it, but
Judge, it
Judge-
wasn't reversible error in opening. It's never been addressed in the closing.
it's not reversible error under the case law. Not one statement made in the middle of an hour and 20-minute closing that he did. So I'm going to deny the motion for mistrial. What's
Well,
your
I have
next
another
one?
one, Judge.
Yes, sir, you said
It's
you had
in,
to.
it's in reference to the piece of paper he said was worthless, the life sentence. When he,
Worthless, is that the word you used?
that's exactly what he said.
Hold on.
He said it was just another piece of paper, Judge.
Hold on, let me find it.
Yeah, we had made multiple objections that were overruled.
Hold on, Mr. Lemon, let me do one thing at a time, okay? The reality is it would be another piece of paper in Mr. Lloyd's life. That's what he actually said, and that's found at 11:03 in the rough draft transcript. Mr. Williams' response to that? So, I'm sorry, you objected to it. I overruled, well, no, I actually sustained that objection, so.
Right, and
is
then
that
I asked for it to come sidebar, and you said you'd deal with it afterwards.
Right,
So I'm
so-
moving for a mistrial based on that as well.
right? Your response, Mr. Williams?
State's position is that it is no error whatsoever. The defense counsel has told these jurors on multiple occasions, there are documents and evidence that Mr. Lloyd has multiple life sentences. It is argument. It is also factual that if they give him a life sentence, it has no meaning as to Mr. Lloyd's future as an individual. I'm unaware of any case law that prohibits me from making that argument, now that they have made the decision to bring it out.
All right, I will say, before I ask you to respond, that judgment sentence is in evidence without objection. So the multiple life sentences are in evidence. So why, do you have any case law that says that's a mistrial?
No, I understand, Judge.
Can you hear me? I'm really trying not to take this off because I have the clerks near me.
Judge, it's not to say that he's not serving life. It's to suggest that he's not receiving a penalty for his previous sentence.
So do you have any case law that, I'm asking, is there any case law on this issue?
Ms. Miller's looking for some, Judge.
Okay,
And Judge,
yes, sir.
I would also note that I intentionally argued it as to the weight of the prior violent felony aggravators. That was in the same section, and that's why I put it there, because it does go to the weight of the prior violent felony aggravators.
You were arguing, then it got interrupted by the problem with Mr. Lloyd. Okay. Ms. Miller, anything on cases? Sure.
Can I use the restroom while she's doing that, Judge?
Actually, I need to take a quick break. It's okay. Thanks. They can hear me. Thank you. Why don't we take a 15-minute break, and we'll return to this when we come back. So, I need to take a break myself. All right, court's in recess.